you rightly mentioned my judgment and the court, where I also said, in fact, the way mediation movement is catching up in this country, there is a dire need to enact Indian Mediation Act. This is what I said after your quote, which you said. Now, the question is that why act? Before that, if I take only 2-3 minutes, because we are talking of why Mediation Act, but I want to go a step, before that. Why mediation at all? What is the need and why there is a mediation? As I said, that I think we have very informed audience today, and we don't have to justify much. But what I want to say is that, look, what happens in every society, disputes take place, conflicts, they do arise between the parties. But at the same time, in every civil society, there is a desire to resolve those conflicts through peaceful means. And if we go to the, to the earlier periods, primitive periods, etc., and even in the family, when the a dispute would arise, they would first try to resolve it within the family, or whether it is family or any neighbors, or it may be partnership firms, etc. And even in a commercial dispute, so they first try to negotiate. Negotiation is the best form, it is always thought. Yes, over a period of time, it is always, it was also realized that, look, it is not possible in every circumstances that the parties can mutually settle between themselves. And over a period of time, there should be some third party, etc. And we come to the court system where the courts resolved. But then, after having tested the court, I have been myself judge for 20 years and have decided the cases. I was before that counsel for 22 years, so associated with this legal system for more than 40 to 43 years now. But still, I feel ever since I was, I would say, apprised of the mediation and its benefits, I always felt that in many circumstances, mediation is the better form of access to justice. Now, here is a system where it's a party autonomy. Again, in a way, we are going to primitive system where the two parties are trying to decide between themselves. Yes, in mediation, through the intervention of a third neutral person who is mediator, and which happens in conciliation proceedings, etc. also. But then my belief is that why I say so, that in the circumstances it becomes the more important, or rather better form of access to justice. Now, justice is what we perceive. We need not go to jurisprudential basis, etc. of that outcome of a particular dispute, which is acceptable to both the parties. Because in a adversarial system, one person would remain aggrieved and he may go up to the highest court. But even after highest court also, he would still feel that no, something which I wanted has not happened in my case, but now he has no further opportunity of filing appeal, so he has to rest it with that. On the other hand, the mediation is why we call it win-win situation, because the resolution which is found is acceptable to both the parties. But what I'm trying to say is why this happens. There are two things which I wanted to emphasize. Number one, as in contradistinction to the adjudicatory process, because arbitration is also in a form of adjudicatory process. Here, it's not only one solution which is possible in legal thing. There may be variety of solutions, and the parties can pick depending upon the situation. They are able to maintain their relationship and continue that relationship. Many times it happens that even a broken relationship, it gets re-established. And the entire mediation, if I say so from my angle, it is in an adversarial, disputes, when it is I versus you. Though I see my case from my point of view, I would never see whether you are right or wrong. Though I always perceive I am right. And likewise, you will also think. So it is I versus you. In mediation, from I versus you, we come to a situation of we. Because we sit on a table, we try to see the both sides, etc. And this what I call is the principle of synergy also, which takes place. Now, in view of this, if I give here only two examples, because it's always better to I mean, support it with anecdotes. And these are real examples. In one case, what happened, it's a matrimonial case, husband and wife, they could not get along between themselves, and they went for divorce. They agreed for divorce. Divorce was granted by mutual consent. But then the issue was at that stage of the alimony or what you call maintenance, etc., which is to be given to the wife. At that stage, the matter was referred for mediation. And you know what could be the outcome? Now, had this matter remained in the court, because they were married only for 2 or 3 years, could not get along, and I mean, maybe short-tempered or whatever, they thought of taking divorce. But then when it goes to mediation, and thanks to the efforts of that mediator who could find out that the main reason, even for, I mean, it was only small wear and tear in the relationship which had led to that mediation. And the outcome was they realized their mistake and they got remarried. Now, this thing you can never achieve in court. The court would have at the most granted this maintenance, and the parties would have parted ways. Now, another example which I give is of Levi's jean. It was a suit which was filed in the court of, and this suit related to the permanent injunction that the defendant was violating the trademark Levi. That defendant had its own factory. He was manufacturing the garments and putting the label of Levi on it. So it was clear case of, I mean, in that sense, taking away the trademark of another person. Suit was filed, and the temporary injunction was granted. Now, in a case like this, what would have happened in the court? There would have been a permanent injunction also, and some damages as well, which could have been awarded to the plaintiff. But again, to tell you in a nutshell, that in the mediation proceeding, what happened, the mediator goes into the needs of both the persons. And when it came to know that in any case, Levi's are not the persons who are Levi's are not the persons who are getting it manufactured from themselves. They go to market and they get it, I mean, all these garments stitched from outsiders. So therefore, the arrangement was worked out where the person who was defending and who was violating that, and he had his factory, he started getting orders from Levi and was in a legitimate way started giving it to Levi. Now, in a court, as I said, permanent injunction would have led to closure of his factory, unemployment of 100 people, he had taken loans of 20-30 crores, all that would have gone. So this is what the mediation can do, and miraculous situation. Now, good thing is, next thing, if I may say so, in India, as you said, that I said in my judgment that the mediation is here to stay, it has evolved. Now, in India, in 15 years' time, mediation has taken large strides, because 2005 was the first when the pilot project was started in T. Sarari by the MCPC, Mediation and Conciliation Project Committee of the Supreme Court. And I still remember the way advocates had opposed. They thought that it will snatch away their practice if everything goes to mediation, without realizing what mediation actually is. And as I always say, ADR was perceived as alarming drop in revenue insofar as advocates are concerned. ADR, alarming drop in revenue, instead of alternate dispute resolution. So, but today, in 15 years, the advocates are so much now sensitive towards this and sensitized about it. Everybody wants this mediation. They know the powers of mediation, and they know the advantages of mediation. Now, therefore, it has its own now entire ecosystem in our country which is developing of the mediation movement. Here we need mediators, which are maybe different from judges. They may be lawyers, they may be non-lawyers also, but then the mediator trained mediators, the training, etc. is required. Then who will be certified? Like an advocate who is to practice, he has to be a law graduate. But then what kind of training is to be required to make him a certified mediator? Then we have advocates who appear before them. That mediation advocacy is somewhat different from that. Then the process of mediation, that how it should carry on, confidentiality and the procedure, etc., ethics of the mediator while conducting the mediation. Then most important thing is that if the mediation settlement takes place, we have section 89 today. If it is court annexed mediation, matter is pending in the court, and from the court it will be referred to the mediator, and if mediation settlement takes place, it will come back and decree will be passed. But suppose it is de-horse the court annex system, it's a pre-litigation mediation and settlement takes place. How that settlement would be binding on the parties? If one party, because if in the first case, when the suit is pending, the court can pass a decree and become binding thing. In the second case, if one party ultimately backs out, then the other party has to file the case all over again. Now, therefore, settlement, if it takes place, has to be enforceable also. For all these reasons, coupled with only, I'll take now the one last minute and we'll say the need for act, I'm saying, coupled with the fact that we are in the age of globalization. Mediation is now the buzzword in commercial world all over. And even all those arbitration centers also, be it LCIA, be it in bilateral investment treaties, etc., which we call ICSID, etc., they have now compulsory mediation process first. So it can be a hybrid system, med, or med, or whatever. But then they think there also, even in arbitration, we should start with mediation first. It is now recognized by our legislature in so many acts, like in commercial court acts also, for some types of cases, pre-mediation is there. And now with this, I was talking about international this thing, and if the settlement takes place, how that is to be enforced. So UNCITRAL has come out with that model law on which Singapore Convention was passed last year. India is one of the signatory. Now, if the settlement at international level of the commercial dispute, which is cross-border ramification takes place, once we have become, and we have, I mean, signatory to that, we have to ratify in the form of a legislation. So all these factors cumulatively are there which justify that today we need an act. What kind of act it should be, we can talk about it later. So this is what I feel, that there was a need, and all that was in my mind when I pronounced that judgment.